Today on UPSC Polity View, in today's age of modern economy, predicting and analyzing the impact of insolvency and bankruptcy is important than ever before. Hello and welcome to UPSC Polity View at UPSC Practice. Let's discuss about the Insolvency and Bankruptcy Code 2016. The Insolvency and Bankruptcy Code 2016, or IBC in short, is the bankruptcy law of India which seeks to consolidate the existing framework by creating a single law for insolvency and bankruptcy. The Insolvency and Bankruptcy Code 2015 was introduced in Lok Sabha in December 2015 and it was passed by Lok Sabha on 5th May 2016 and by Rajya Sabha on 11th May 2016. The code received the assent of the President of India on 28th May 2016. Certain provisions of the Act have come into force from 5th August and 19th August 2016. The Bankruptcy Code is a one-stop solution for resolving insolvencies, which previously was a long process that did not offer an economically viable arrangement. The code aims to protect the interests of small investors and make the process of doing business less cumbersome. The IBC, or the Insolvency and Bankruptcy Code, has 255 sections and 11 schedules. Let's take a look at the history of this act. The Insolvency and Bankruptcy Code 2015 was introduced in Lok Sabha on 21st December 2015 by former Finance Minister late Arun Jaitley. The code was referred to a joint committee of Parliament on 23rd December 2015 and recommended by the committee on 28th April 2016. The code was passed by the Lok Sabha and the Rajya Sabha on 5th May and 11th May 2016 respectively. Subsequently, it received assent from President Pranab Mukherjee and was notified in the Gazette of India on 28th May 2016. The Insolvency and Bankruptcy Code was passed by Parliament in May 2016 and became effective in December 2016. Section 243 of this code repeals the Presidency Towns Insolvency Act 1909 and Provincial Insolvency Act 1920. The first insolvency resolution order under this code was passed by National Company Law Tribunal, or NCLT, in the case of Synergies Dure Automotive Limited on 14th August 2017, and the second resolution plan was submitted in the case of Prowess International Private Limited. The plea for insolvency was submitted by company on 23rd June 2017. The resolution plan was submitted to NCLT within a period of 180 days as required by the code, and the approval for the same was received on 2nd August 2017 from the tribunal. The final order was uploaded on 14th August 2017 on the NCLT website. Let's take a look at some of the key features of the Insolvency and Bankruptcy Code. The Insolvency Resolution. The code outlines separate insolvency resolution processes for individuals, companies, and partnership firms. The process may be initiated by either the debtor or the creditors. A maximum time limit for completion of the insolvency resolution process has been set for corporates and individuals. For companies, the process will have to be completed in 180 days, which may be extended by 90 days. If a majority of the creditors agree. For startups other than partnership firms, small companies and other companies with asset less than Rs 1 crore, resolution process would be completed within 90 days of initiation of request, which may be extended by 45 days. The Insolvency and Bankruptcy Code Amendment Act 2019 has increased the mandatory upper time limit of 330 days, including time spent in legal process to complete resolution process. The Insolvency Regulator. The code establishes the Insolvency and Bankruptcy Board of India to oversee the insolvency proceedings in the country and regulate the entities registered under it. The board will have 10 members, including representatives from the Ministries of Finance and Law and the Reserve Bank of India. The Insolvency Professionals. The insolvency process will be managed by licensed professionals. These professionals will also control the asset of the debtor during the insolvency process. The Bankruptcy and Insolvency Adjudicator. The code proposes two separate tribunals to oversee the process of insolvency resolution for individuals and companies. Number 1. The National Company Law Tribunal for companies and limited liability partnership firms, and number 2. The Debt Recovery Tribunal for individuals and partnerships. Let's take a look at the procedure followed by the Insolvency and Bankruptcy Code. A plea for insolvency is submitted to the adjudicating authority (NCLT) in the case of corporate debtors by financial or operation creditors or the corporate debtor itself. The maximum time allowed to either accept or reject the plea is 14 days. If the plea is accepted, the tribunal has to appoint an interim resolution professional or IERP to draft a resolution plan within 180 days, which is extendable by 90 days. Following which, the corporate insolvency resolution process is initiated by the court. For the said period, the board of directors of the company stands suspended and the promoters do not have a say in the management of the company. The IRP, if required, can seek the support of the company's management for day-to-day operations. If the CIRP fails in reviving the company, the liquidation process is initiated. Is the Insolvency and Bankruptcy Code a remedy to all banking issues? Insolvency and Bankruptcy Code Bill was introduced in the Indian Parliament by the NDA government in 2015 but got final clearance in May 2016 Parliament session. It was believed that this bill will resolve all the banking issues present in the economy. The main reason to introduce this bill was to fasten up the long insolvency process, which it did. After this bill, the insolvency process for the company is 180 days with an extension of 90 days, and for startups and small companies, it is 90 days with an extension of 45 days. The question is, will it resolve all banking issues? And the answer is no, as India's banking industry is going through a very difficult phase. Banks are merging up due to bad loans, and all this hustle can't be simplified with this bill. The IBC will only bad debts that are disclosed. Undisclosed bad loans or bad loans that get disclosed after the victim absconds remain untouched. And there are many incidents in past years in which creditors flew away from the company and the country after being unable to pay off the loan that they took. But the IBC did improve the economic system, and the impact can be seen. The economy is clearly stabler. Thank you very much for listening to this article on the Insolvency and Bankruptcy Code 2016. For more such discussions, get the UPSC Practice app from the App Store.